Hello and namaste, this is Kishore. Welcome to our Facebook page and YouTube channel. Today is our third episode of our season first. Thank you for your feedback and suggestions in the last couple of episodes. We really appreciate that. And we'd like to request you to subscribe our YouTube channel and like our Facebook page for the weekly updates. Today's topic is about the contract of the sale, the points and the legal matters you need to remember before you sign the contract. What you need to know before you sign the contract, or what you need to check on your contract before you sign it. Hopefully you will like this episode as well. Once you have had an offer on a property accepted, the real estate agent will usually give you a contract of sale which you both and the vendor must sign to make the sale legally binding. Below we look at some of the common conditions to check in the contract. Note this checklist is for your information only and must not be construed as legal advice. Before you sign, you should engage a solicitor or conveyancer to act on your behalf and check the contract of sale fully. The conveyancer or solicitor will be able to explain any conditions that are not clear to you. Most states have a standard contract of sale. The specific terms will vary from state to state, but typically the contract of sale will contain the following information. The name and address of the vendor, address of the property, and in some states the physical dimensions of the land, title reference and plan number, a list of any chattels and fittings included in the sale. Chattels are items not attached to the property, such as curtains, and unless otherwise stated in the contract, can be removed by the vendor prior to settlement. Pictures are things like light fittings that are part of the building and are usually included in the contract. The purchase price divided into deposit and the balance. The amount of deposit required varies depending on which state you are in. In some states, the deposit is not a legal requirement. Settlement details, building inspection reports. So these are the things included in the standard sale of contract. So these are the general requirements they have in the contract as well. So make sure you check those properly. Right, there is general conditions. General conditions are written into the standard contract of sale and cover issues such as loss or damage before settlement, what happens if there is a breach of the contract, how the money is paid, etc. There could be any special conditions as well. Special conditions are extra conditions that are put in the contract by you or the vendor. They can be about anything to do with the property. For example, that the contract is subject to you obtaining finance. There will be penalties for a delay in the settlement. That the sale is subject to tenancy, etc. That you take the property in its current conditions subject to latent and patent defects. In such instances, you must ask your solicitor or make necessary inquiries, as there may be a possibility, although not necessary so, that there may be a defect which, if you were aware of, would put you off buying the property. As the name implies, restriction restricts the use of the property. An easement is an interest in land which grants a person that right to use the land of another. The most common form of easement is where a government authority has a right to run electrical mains or drainage through private property. Another example is where a neighbor has the right to use the driveway of an adjoining property. It is important to check for any registered easements which appear on title and unregistered easements with private agreements. So if you are buying off-land property, make sure you check the sunset clause as well. If you are buying off-land, the contract of sale should contain a sunset clause. This enables you to cancel the contract if the plan or development is not completed by a certain date. So make sure that you check the date, and if not completed, you can take an action on that as well. The contract may contain information about a cooling off period. During the cooling off period, you may change your mind and withdraw from the purchase. A cooling off period is not offered as a general condition in all states, and the length of the cooling off period may vary. Check the contract of the sale carefully for details. For example, in New South Wales, if you rescind the contract during the cooling off period, you will have to forgo 0.25% of the property's purchase price. So just keep in mind to check the cooling off period according to your states. The other one, the last, would be the GST. Check whether the property being sold is inclusive or exclusive of GST. Failure to ensure that the contract clearly addressed the GST can prove very costly later on. So this is a very important part as well. So hopefully you get some information from today's episode. Obviously these information are shared as in general information. Make sure you check with your solicitor or conveyancer to get more details or legal advice. Please do ensure that to subscribe our YouTube channel and a Facebook page, and thank you for your support.